Welcome everyone to today's compliance webinar. These are ALTA's presentations we offer on issues important to title and settlement professionals. I'm Jeremy Yowie, ALTA's Vice President of Communications, and today we've got a great webinar lined up to help you understand the latest laws regarding consumer privacy rights, as well as redaction trends. Before starting, I do need to touch on a few housekeeping items. First, if your audio is choppy, you may have a weak internet connection, so you may want to try and select the telephone option. A copy of today's presentation can be downloaded from the handout section there in the GoToWebinar window on your computer screen. You'll also get an email with a link to access the presentation afterward. All participant lines are muted for today's discussion. At any time you have a question, go ahead and submit them through the questions box. We'll hold a little bit of time for Q&A. Also, as a reminder, the presentation is being recorded. A link to the recording will be sent to everyone, and you can always find the archive of all of our recorded webinars on ALTA's website at alta.org/webinars. Again, that's alta.org/webinars. I do need to extend a thank you to Old Republic National Title Insurance Company for sponsoring our compliance webinars this year. So thank you, Old Republic. Now let me introduce today's speakers, and then we'll get to the presentation. Joining us today is Elizabeth Riley. Liz is Senior Privacy Counsel, as well as Regulatory and Compliance Counsel for Fidelity National Financial. And we also have Steve Jaden. Steve is Senior Vice President and Chief Privacy Officer for Old Republic Title. Liz co-chairs ALTA's Data Privacy Work Group, and Steve is also a member of the work group. And also joining us today is ALTA's Elizabeth Blosser. Elizabeth is ALTA's Vice President of Government Affairs. She leads ALTA's data privacy efforts and coordinates with many other groups on this issue. And definitely want to take a moment here just to recognize Elizabeth, recently promoted for her dedication to industry on many fronts. So congratulations, Elizabeth. And with that, I'll turn the presentation over to you guys.
Thanks, Jeremy. So we've got a lot of information to go through today. As we go along, feel free to submit your questions in the chat box, and we'll hopefully have some time to answer those towards the end of the presentation. Also want to give a shout out to Liz and Steve for taking the time to join us. They do so much work on behalf of the industry on this issue, and it's fantastic to have such really knowledgeable subject matter experts to work with. So one of the first things that people ask when you start talking about the issue of data privacy is, how did all of this sort of come about? What is driving this push to data privacy legislation, both on the state and the federal level? And I think one of the answers is we've sort of clicked our privacy away over the last handful of years, and now it doesn't really matter if you're a Republican or a Democrat. People tend to agree that they want their data privacy back. And so that's kind of how we start the conversation. But Liz, I'm hoping you can kick us off by talking a little bit about some of the data on the slide, because there's some really fascinating numbers.
Sure, I can, and thanks everyone for joining us today. To start off, yeah, you look at the numbers, they're staggering. 2.7 billion Facebook users and 500 million tweets per day. I should mention these are 2019 numbers. So with the days of remote work and I guess remote life, essentially amid the pandemic, we probably could imagine that these numbers have increased in 2020. But I think the theme is that the internet has brought convenience to our day-to-day life. I mean, it's brought a lot of connection, but privacy advocates are asking and asking, with more frequency and more attention today, if this convenience and efficiency is coming at a price that's too high. And the question is the information that we share knowingly or unknowingly when we avail ourselves of these internet resources, that's a commodity, and it's got significant value to others, including data brokers and retailers. And you know, is this really a fair exchange?
So thinking about the history of data privacy, we're going to talk about California a lot today. California passed the first in the country data privacy law, and that really all started at a cocktail party. These days we have virtual cocktail parties, but it was about data similar to what is on the slide. And it came up in a cocktail party conversation, and it led to this huge push in California to get something done on data privacy. So Steve, your home state, tell us about the cocktail party and what ensued after that.
Well, and thank you for everybody joining this fun call. And yeah, it did start with a lovely cocktail party, and this was pre-COVID. It wasn't virtual, it was an in-person cocktail party. And there were many news sources that kind of wrote about it at the time, but the story goes this way. So it all revolved around a wealthy real estate developer from San Francisco, Silicon Valley, named Alistair McTaggart. So he allegedly expressed concerns on the future of consumer privacy at this cocktail party while discussing consumer data practices with an engineer from Google. And this basically led to the first round of a ballot initiative. And we'll get more into some of this. But California lawmakers and privacy advocates got wind of this and met with McTaggart. So there was this alleged ballot initiative, and it was moving forward. It looked like things were going to actually happen. And McTaggart met with the lawmakers, convincing lawmakers in California that if they embrace a true writing of a privacy law, he'll remove the ballot initiative, which he did at the time. But know that that lovely effort of ballot initiative being removed and CCPA, the California Consumer Privacy Act, and what is now the law, that was written in approximately 7 days. So when you think about all of the effort, all of the angst, all of the things that are within the California Consumer Privacy Act, this thing was built in a very, very short period of time. And we'll get back to McTaggart a little bit later in the presentation.
Yeah, he's an interesting character and definitely at the center of all of this. So Steve, if you think about data privacy, data security, as we look to the future, you know, in the past, there was a smaller group of industries that were really regulated, and now it's really everybody is in this bucket, and these data privacy laws apply to everyone. What does that mean for real estate?
Well, certainly real estate has expanded in the technology space, from social media as our initial slide, and you look at all the different social media aspects regarding the engagement in the real estate industry, and digital advertising become a big part of the real estate market. And operating in these areas requires a really deeper understanding of the privacy laws and regulations associated with the space. You'll notice on this slide that, you know, there's data brokers, and you know, there wasn't a lot of conversation regarding data brokers years ago. I mean, there certainly is now. And that brings on a whole host of things to consider under privacy laws. And depending on what a business is doing with their consumer data, a business could easily fall into many of these new buckets as stated on the slide. And really, it all boils down to knowing what, where, and how you are dealing with consumer data. And that's been a big change into what we have to face today.
So one of the things that's really interesting to me about data privacy laws is there's been this fundamental shift about who owns data. So you talk about data brokers and data aggregators. In the past, you thought if somebody collects data and houses it, maybe adds additional information to it, they own that data and they can do with it what they like. Under comprehensive data privacy laws, that all changes. Comprehensive data privacy says I own any data that relates to me regardless of where it exists, and I have certain rights as it relates to that data, whether it's the right to get information on what data is being kept and stored, how it's being used, a right to have it changed, deleted, provided to me in a portable format. All of these rights related to data, and it is a shift in how we think about the information that we all hold and retain, and who has rights to that. So here on this slide, there's some information about some of the core concepts and things to think about as you start to approach data privacy. I'll start with you, Liz. Could you talk about one of these core concepts that you think it's important for our audience to be focused on?
Absolutely. And, Elizabeth, you're exactly right. It's this fundamental shift in the view of who owns the data that's driving, current privacy regulation and the increasing interest in privacy regulation. And sort of view it as they're looking at two things, from the data owner's perspective, not necessarily who's custodian of the data, who owns the data owner, and these core concepts, the privacy policies, the disclosures. The expectation is transparency on the part of the data custodian, the person or entity that possesses the data, so that the person who owns the data knows, whether or not the data exchange is going to be fair or unfair, or can make that determination. What are the terms of me giving you my data? What are you going to do with that data? And I've got to know that up front before that I give you my information. So I think that's one big thing. It's these concepts that are sort of rooted in transparency. And the other, I think core concept that we're seeing in the privacy regulation is this concept that there are certain terms that are just fundamentally unfair, that there are certain uses of the data that are either unnecessary or where sort of the terms of the bargain is so unfair that the law is going to prohibit those uses. And so you're seeing limitations on the use of personal information. I know, Steve mentioned CCPA. I think that's something that's a big part of CPRA, is drilling down on sort of limitations on use of that information. But those are concepts that it's worth mentioning. Transparency and limited use have been around our industry for almost 2 decades. The financial services space has been regulated by GLBA, and as insurance entities were regulated by the states and subject to the GLBA requirements. But we have to already adhere to a GLBA privacy rule, which requires the disclosures and limits our use of the information. So while these aren't new concepts to our industry necessarily, they are new to, say, the data brokers and other industries out there. But I also think as we within the industry sort of look towards, Steve mentioned digital advertising, sort of that digital presence and partnerships within the digital realm, we will encounter, I think, more frequently sort of these expectations in other ways.
What about you, Steve? Anything jump out to you on this slide to highlight?
Well, certainly, the shift from, I remember when GLBA came out, and that was such a huge shift at the time. And that, oh my gosh, we're now going to care about privacy. And it was a huge push in industry, industries beyond even the title industry had to, in the financial services sector, had to apply and get all compliant with GLBA. And it was all about not wanting to share personal data. And now you look at where we're at now with people sharing the most intimate details on Facebook, as an example. And here we are in a very, very different shift. One of the things, and Elizabeth touched a little bit on it, is the digital advertising. And when you think about website disclosures and how you're operating, your business, it's possible you may be using some digital tools on your website, your company's website, that may capture some of your visitors' data. And when you get into the nuance of some of the laws associated with this, you might want to think about what you're doing from a disclosure perspective. So tracking some visitors' activity as it relates to visiting your website is probably okay as long as you have it appropriate disclosed. And what are you doing with that? What types of things are you capturing? And it's big in the news. There's certainly some large industries out there that have gotten in some trouble in the privacy world in just failure to disclose, not actually what they were doing. So that's one of the things I'd certainly lift off that slide.
Yeah, that's a really important point. I think it's easy for us all to think about the data that we collect to do a transaction, that sort of active data collection, and then there's sort of some of this passive data collection that happens in the background, and really understanding what all that entails in your operations. So we've had data security laws for a long time. Now we have these comprehensive data privacy laws, and a lot of times they're together in legislation, but I think it's really important to understand the distinction between the two, because they are, well, they're often tied together. They are two different things. So my little trick that I use to remember is data security is all about what happens when you lose data, and data privacy is all about what happens when you use data. So privacy using data, security is about losing data. I ask both of you, do you continue to see this trend moving forward where we'll see both data privacy and security being addressed together in the same pieces of legislation?
Elizabeth, my thought is, I mean, CCPA is an example, which is clearly focused more towards privacy. There's still an expectation of that reasonable security. We're not necessarily seeing in the privacy laws sort of the specifics of cybersecurity regulation. We may see elsewhere, say in New York's Reg 500, and I think that's appropriate. I mean, the concepts can be addressed concurrently. But, we've seen it's certainly a challenge because there's not, in sort of a full overlap. You've got, data security also speaks to protecting business assets, not just necessarily personal information. And I think the focus of a lot of these privacy regulations, to protect personal data, there have to be security controls in place to mitigate against that data loss, which, as you said, how you lose data, it's falling into the wrong hands. Sort of the bigger focus and factor in privacy regulation has been intentional sharing in compliance with your intentional sharing practices. Are those disclosed to the consumer? Is the consumer on board with that sharing? And as Steve mentioned, with regard to digital advertising, there may be instances where, even, the company may not be aware of some of the behind the scenes sharing, but now the compliance, burden is on the company to make sure that sort of every link in the chain is properly addressed from a privacy compliance standpoint.
In addition, I think it's good to remember technology is generally ahead of laws and regulations. And so there's always a little catch up going on, trying to, plug holes when we've got all this, cool ideas and technology moves so fast. And I think these, as Liz even mentioned, you can't have good privacy protection without good security controls in place. So they're very much more hand in hand and will continue to do so. I think lawmakers are going to begin to connect the dots a little bit more as we move down the future of this. And certainly the definition of protected data is more broadly defined in what we see in the privacy sector. And the security sector is probably going to catch up.
Lots to think about, and lots sort of headed everybody's way. So let's talk a little bit about the timeline for how things have happened. Really, this whole push started in the European Union with their data privacy regulation, GDPR. It was quickly followed up with action in California that came out of the infamous cocktail party. You saw that the cocktail party got you legislation created in a week, so it wasn't surprising that in 2019 and 2020 there were some tweaks and changes made to CCPA. I had anticipated that 2020 was going to be the year of data privacy law, and that we would see a lot of bills passing in states all over the country. We had sort of all of these different models people were looking at. We were worried about a patchwork of state laws that would be, you know, coming into effect around this time, the beginning of next year. But COVID hit, and data privacy for the time being got pushed to the back burner. There's been some conversations about data privacy and how it relates to COVID and that sort of thing, but really comprehensive data privacy has been a little bit of a back burner issue. But you know, in 2020, I really wish I had a crystal ball. We all could have used a crystal ball going into this year, and so I'm going to ask you guys what you see, if you had your little crystal balls going, what you see coming down the road. Liz, we'll start with you and have you focus on what do you think is going to happen in the states with data privacy legislation in 2021?
I wish I had a crystal ball too. You know, I mean, 2020 took a hard right. And, you know, Elizabeth, you're right. There was so much, we were following so much. The first quarter of 2020, so many different states had introduced privacy legislation, and we were watching it all. And then, you know, there was a huge shift in legislative priorities, obviously with the pandemic. And I think given where we still are, sort of within, you know, the pandemic, where it's not behind us yet, it's likely that we're going to continue to see legislative focus on the more immediate pandemic-related concerns, you know, budget, response, and otherwise, you know, I think the messaging for a number of states has generally been that there's little room on the legislative agenda for anything that is not necessarily a consensus issue or a consensus bill. And so for data privacy, we may see a number of states, you know, introduce legislation, especially states that had introduced it in 2019 or 2020 and didn't get it across the finish line. But, you know, the big question will be whether it will actually move, because, you know, there is certainly, I think, bipartisan interest and support for the concept of data privacy, but some of the nuances of data privacy legislation can be quite partisan, you know, private cause of action, you know, other issues that tend to kind of create that divide and not get us consensus. So yeah, I don't know if it'll be like 2020 where you have some states, a number of states, New York or Washington, Texas, introduce privacy related legislation, but we may or may not see much movement there, depending upon, you know, the legislative interest.
Yeah, it's been interesting. You know, my home state of Washington, I think we all figured would pass legislation last year. It's going to be introduced again next year. I guess that was technically this year that we thought it would pass. But, you know, there are those issues where people get hung up on, and, you know, we've seen it too with what's happening at the Uniform Law Commission, with their trying to draft model legislation, and certainly so many questions around private right of action and preemption. Steve, I'm going to ask you probably the harder question, because there's a lot of factors that go into it. Like, what do you think is going to happen at the federal level on this issue?
Yeah, well, I don't know about my ability to predict is really very solid or not, because this is a very, very odd environment. It's very possible that federal legislation could take the same path as it in 2021 as it did in 2020, which was it didn't really go very far, because you know, we're still faced with a pandemic, and there's a lot of focus on that. I also, you know, though we you know, we still have a pretty serious runoff election that could shape the Senate, and we don't know exactly where that's going to be. So I think there's some that believe with the Democratic leadership change, this could take on a greater level of focus as far as, you know, some federal privacy legislation. But it's going to be very interesting to see what this thing looks like after the runoff in Georgia. And it's likely, depending on how that goes, California, good, bad, or indifferent, may be the status quo. That might be the baseline that as Liz mentioned and Elizabeth mentioned, where states may be going. There is some, federal legislation that CLTA has been active in contributing along with U.S. Chamber. Most notable is the SAFE Act, which is setting an American framework to ensure data access, transparency, and accountability act. If anybody didn't know that little mouthful. And there's also the Information Transparency and Personal Data Control Act that we're CLTA and our working group is very active associated with. Nobody wants a patchwork of different privacy laws across the US. So certainly nobody in industry. The compliance components to have all of these variances is a real challenge. So it's good that we do have a baseline if possible. As Elizabeth mentioned, the Uniform Law Commission, they've been working on their Collection and Use of Personally Identifiable Data Act. Where the traction is on that, there's been some back and forth between even the GOBA carve out as most recently, which is something we really, as an industry, need. And in addition, the NAIC continues to work on a model. They were working on a privacy model and it was moving along, and then they decided to kick all of that to the curb and start over. And you never know where that could be. So that might not be much of a prediction, but that's certainly my observations on the federal front.
I think it's safe to say there's lots happening on the field, right? So, legislation is coming your way in one shape, form, or another. Quick thing before we move off this slide, a big winner on election night was data privacy, and Alistair McTaggart, again, when California did pass CCPA, which was sort of another ballot initiative on data privacy, and we'll talk a little bit more about that. I do want to talk a little bit about CCPA because it is the foundation, as Steve mentioned, of most legislation out there. It does give us a sense of what might be coming. So Steve, I'm hoping you can walk us through a little bit of the high level of CCPA and specifically touch base on how it impacts businesses outside of California. I think a lot of people hear, oh, California's law, I don't need to worry about that, but there are some things to maybe be aware of.
Well, as you look at the details laid out in the slide, and you need to make a determination whether or not your business is actually subject to CCPA, and make sure to have processes in place. I know, having worked, I'm very active with the California Land Title Association, and the way we address this on our FAQs, because it's a little daunting to give a whole lot of direction as far as this, but this is how CLTA answers that question. So a business based outside of California that is a for-profit entity that collects California consumers' personal information as defined by the CCPA, or determines the purpose and means of processing personal information, does business in the state of California, meets any one of those three thresholds described, which are those three bullets right there, may be subject to CCPA. So it's a maybe, and you really need to look at this. But I think that there's something that is changing, and we'll get a little bit more of that into the conversation on the CPRA. So today, the California Consumer Privacy Act's enforcement is done by the Department of Justice. So it's under the AG. And with the election results of CPRA, there's a new enforcement agency that now comes into play. So the California Department of Justice and how they may look in reaching across state lines, that's kind of one thing that you can look at and consider when you're talking about being in a business outside of California still subject to CCPA. With this new enforcement agency, I think the jury's out on that. And, could that have more impact to businesses operating that are subject to CCPA outside of the state of California? So there's more to come on that, but it's one to be thoughtful about if you're subject to CCPA, and certainly Even if you're outside of the state of California, there's a lot of good things that you should have in place and be thoughtful for. Because I do think, and we probably all agree, this is likely coming to a theater near you, however that form is.
I think one of the interesting things on this slide is, you have these thresholds that you have to hit. And, what I've heard from businesses in California, especially small businesses, is that it's easier to hit these thresholds than one might imagine. And just to kind of give people an idea, estimates are companies that have 1 to 20 employees are paying about $50,000 to become compliant with CCPA. Companies of 20 to 100 employees are about $100,000 in compliance costs. And beyond that, for large companies, it's just astronomical, the investment. So something to just have on your radar. We already talked a little bit about some of the rights that people have under CCPA, so we won't get a lot into this slide, but I would just throw out there that, people have the rights to exercise their rights, and you cannot discriminate based on that. So that's another important thing to keep in mind, and I think probably a key concept you'll continue to see in data privacy legislation. Liz, one of the big things about CCPA, we could probably have a whole conversation on it, was the definitions and figuring out sort of what everything meant, and it's been a large focus of some of the tweaks made to CCPA the last 2 years. Can you talk a little bit about personal information and that definition and kind of what all it entails?
Yes, I mean, for many of us, I think in the United States, CCPA presents the most expansive definition of personal information that we've seen. GDPR, the European law, which has some similarities, has an equally expansive definition of personal information, but for those of us, without a multinational or presence within the EU, this definition sort of brought to us the most comprehensive that we've seen yet. And so how to apply this information and whether or not data that you collect falls within this information and what categorization is a significant exercise. But generally, CCPA personal information includes any information that identifies, relates to, describes, is capable of being associated with, or could be reasonably linked directly or indirectly with a particular consumer or household. Right, so that is a lot, and that includes, online information, internet activity, internet browsing history. If you were viewing a website and your IP address leaves that website and goes to another, then that is potentially CCPA personal information. So it's significant, I think, in the volume of information that is captured and types of information that we didn't necessarily previously assign a sensitivity. It's not information that would necessarily be subject to data breach notification statutes. It's far more expansive than that. But something else that's important to point out, Elizabeth, that you mentioned, there are some important exclusions to CCPA personal information as well, and some of those, are very helpful for our industry. CCPA definition of personal information does exclude publicly available information. So that's information that is lawfully made available from federal, state, or local government records. So your land records, your public record information relating to taxes or property appraisers information, that would all be considered public information excluded from CCPA personal information. I mean, two other exclusions that are important are the employee data and the business-to-business information. So even if you're capturing name, address, phone number, email address of somebody who is otherwise a California resident, and in certain contexts that would be considered personal information, if you're engaging with them from a business standpoint, or you're engaging with them as an employee or prospective employee, then that is exempt from the general definition of personal information. though there are requirements elsewhere in CCPA regarding how you would treat employee information. And there are certain disclosures that are required to be made to employees with regard to how the employer would handle their information. But those are, helpful exemptions. It rules out some significant challenges that CCPA compliance would otherwise pose. But those are exemptions that aren't necessarily fixed in the law. There's a sunset of the exemption, I believe, in January 1, 2023, right when the CPRA goes into effect. So that's something that I know the California Land Title Association, and other associations have been very focused on, seeking to retain those exemptions on a permanent basis.
Yeah, we have to give Steve and CLTA lots of props and kudos for their work in this area. When you think about having, privacy rights related to things like employee data, that raises a whole bunch of questions. And Steve, maybe you can speak to the great work you guys have been doing in the state, because I know you've been an integral part of those efforts.
Well, I can tell you, the CLTA efforts first were trying to address the possibility that the California Consumer Privacy Act may not have been voted in, because this B2B employment carve-out was due to expire in a few weeks. So one of the things we worked very, very heavily on was Assembly Bill 1281. It's moot now because the proposition did pass, but there was an incredible amount of effort, and hats off to the members that I work with at CLTA. In working with Cal Chamber, we really did a lot of the heavy lifting to make that happen, and this was for industry. And you can, there's a lot of folks that are impacted by this, and the title industries wasn't the target. We're just kind of caught up in it, but we really did a lot of the heavy lifting on that. So now we have, what was Prop 24, the California Consumer Privacy Act, where that carve out is extended for 2 years until January 1, 2023. So we're working very, very closely, again, CLTA with Cal Chamber. We're hearing some positive news, even though we have, obviously a very unusual set of circumstances again in Sacramento. But we do think, the main obstacle has been labor and some concerns that they've raised on the employee carve out. And we think we've got enough attention to move that forward. I am a glass half full person, usually very optimistic anyway, for those of you that know me. But this is, we're encouraged. And while there's a 2-year span for us to fix this and make it permanent, we're addressing this very aggressively right now, heading right into 2021, because we don't want to be in year 2 feeling uncomfortable associated with it, because this is very, very important, not only for our industry, but others. But CLTA has been extremely involved in making this effort move forward in Sacramento.
Absolutely, a great model for leadership on this topic. This slide talks a little bit about contracts. We've left it in here so that it's just in your presentation materials, but we're going to touch on it a little bit later. This slide kind of outlines the whole CCPA process, but the little box in red is the piece that's really super important for our industry. And so I'm hoping that Steve, you can maybe talk a little bit about these exemptions in red, specifically the GLBA exemption.
So I can talk about this a little from, we're a company that's subject to CCPA. And so the exemption response is one we face regularly. And you need to have a deep understanding of your operation to determine what may apply when we talk about these exemptions. And And, some of the examples, in order to complete the transaction for which we collected the personal information, that may be an exemption as you look into these things. In order to detect security incidences, protect against malicious, deceptive, fraudulent, or illegal activity. Other examples of what could be an exemption as far as the requests that may come in from a consumer. In order to comply with a legal obligation. There could be a subpoena, there could be all sorts of different legal obligations where when we have this data to handle a transaction, how do you manage a request coming from the consumer? And then some of the biggies, it's a type of personal information that falls outside the scope of CCPA. So we have the Graham-Leach-Bliley carve out in essence. And we have the HIPAA and the COPA exemptions as well. Those are just a few of how you would look at handling these types of exemptions. And I know that we're going to get into this in a little bit, but it's really important to know the data that you're bringing in, where it's stored, and how you're categorizing it, how you're dealing with it. Because until you have that, you really can't understand what exemption something might fall under.
One thing I'll add to on the GLBA carve out. So, this is something that we as an industry are pursuing at the state and federal level. You should know on the ALTA website, on the data privacy tab, there is language to be included in state legislation that provides the GLBA exemption. You should feel free to go download that, use that. There's talking points, all kinds of information there that you can use in your state advocacy. But the really key thing for our industry to get included in any state legislation is going to be the GLBA language. So really encourage people to be taking a look at that. So Liz, everybody's favorite topic is litigation, of course. And there's been some concerns about litigation around data privacy, private right of action. Can you talk a little bit about what that looks like under CCPA, since that's kind of a model for other places as well?
Yes, and we all love to talk about litigation, but sort of this private right of action within the CCPA seems, it sort of was the gift that plaintiffs' attorneys in data breach litigation had been hoping for and looking for, and just, something that has been difficult to prove in prior data breach litigation has been standing on the part of the plaintiffs. The plaintiff has to have suffered an injury in fact. That injury has to be traceable to challenged conduct of the breached entity or the allegedly breached entity. And then it has to be, that conduct has to be redressed by a favorable judicial decision. So sort of the inability to show that a plaintiff had suffered an injury in fact, that they were harmed, that there was a financial harm, some sort of identity theft or something that occurred as a result of the breach, it has been a challenge to prove, and therefore it's been a challenge for a lot of these data breach cases to move forward in litigation because there hasn't been standing, effectively proven in a number of them. So CCPA comes in and it creates a duty to implement and maintain reasonable security procedures and practices. And those have to be commensurate with the nature of the personal information collected. To remedy a violation of that duty, CCPA created this private right of action. And it is a limited private right of action for consumers whose non-encrypted or non-redacted personal information is subject to breach. And we're talking about, as the slide shows, that narrower definition of personal information. So it's what we're typically used to seeing in California's data breach law and other states' data breach laws: social security number, driver's license number, California ID card, etc., bank account. But there is no need to show that financial harm, that the breach in and of itself is enough to establish standing, and the consumer can recover statutory damages between $100 and $750 per violation. A big change is that right now, within the CCPA, there's a 30-day cure period. So the consumer must first notify the allegedly breached entity that, they've of the breach, and the business has 30 days to cure. I don't know what cure means. Others may have thoughts, but the law doesn't really go into what it means to cure a breach. But if the grievance is not cured, that's when the ability to file a lawsuit and seek those statutory damages kicks in. Under CPRA, that 30-day cure period is gone. So there's no need to notify a business before filing a lawsuit and seeking damages under CCPA in response to a data breach. So, you read the statistics and hear the statistics of how costly data breaches in and of themselves can be. Of course, it's anticipated that having this private cause of action could greatly increase those costs for businesses who fall victim. And you will talk about preparations for CCPA and CPRA in a minute, but we can't overlook or underestimate the importance of having an effective security program, to mitigate against the potential breach, given the potential implications under CCPA of private cause of action and statutory penalties.
Yeah, this is really one of those areas where the privacy and the security come together. So just to touch briefly on CPRA, the ballot initiative that passed last month. Steve, if there's a company that's already complying with CCPA and now they're thinking about CPRA, do they need to be worried? What do they need to be thinking about? This is new, this is different.
Well, I think, one, Liz pointed out the 30-day right to cure is removed. So there's one change. But fundamentally, if a business is subject to CCPA today and they're in compliance and they've done everything accordingly, there's really not a lot of change. There's been an addition to the disclosure requirements, talking about the retention period. You may retain a certain category of data. So if things remain the way they are, that's probably a real minor change that would need to be made to a company that's subject to CCPA and their disclosure requirement in their CCPA notice. But basically, it pretty much remains the same for our industry.
So the message is don't freak out.
Yeah, exactly. It's just, and there's 2 years. So, though this is all kind of put in bed and it sounds kind of solid, it's California. You never, McTaggart started with this ballot initiative, removed it, became law. We have another one. You never know what might happen in the next 24 months.
You still need that crystal ball, apparently.
Yep.
In the interest of time, because we've still got some other information to cover, Liz, can you talk a little bit about preparing? As Steve said, this is coming to a theater near you sooner rather than later. So what can you do now to get started?
Yeah, and I think we've touched on a number of these things already. So just, reiterating them briefly. Steve mentioned, know what types of information you're collecting, know what data you're collecting, where it goes, how you use it, whether you share it. I mean, that's going to be critical for CCPA compliance, CPRA compliance, and likely any privacy regulation down the way. Additionally, I skip ahead to the next slide, updating those disclosures. And this is something we're used to in the financial services industry. We may have our GLBA disclosure, but if you're subject to CCPA, you consider whether you need a CCPA disclosure too, and if so, make sure you're meeting the requirements of the CCPA and in a couple of years, the CPRA. And then something we've talked a good bit about, with regard to the operational compliance, those websites and application notices are important. And what's also really important to understand is sort of the mechanics of your information sharing, what you know and what you don't know, especially with regard to your digital presence. And if you do have, digital service providers or partners, making sure that any of those contracts one, that you have contracts in place, and two, that all of those contracts adhere to the CCPA requirements.
Yeah, I think contracts are just, it's an important part of any of the discussion when it comes to data sharing. Steve, I don't know if there's other things you would add on the contract piece or obligations that we already have under GLBA.
I can just reiterate how important it is to do this, and know that at some point, you know, when we look at the CPRA and the fact that enforcement has moved from the Department of Justice to a new agency that's being formed. It's the new agency's got about a $10 million cost associated with it, and they're going to be funded for enforcement actions. That's how they're going to be paid. So when we talk about the importance of having these structures in place, making sure you've got notices, make sure your contracts are in place, all of those things. We have a new enforcement agency that we don't know. We don't know how they're going to operate. And I think it would be better to think from a super risky perspective, and that they're going to be really difficult, and they're going to bear down on these types of, you know, show me your contract, show me the fact that you have a CCPA disclosure and an information security addendum with all of your third-party vendors. I think we should anticipate that that's coming. And if you're prepared and you're thinking about these, you're going to be in better shape if it comes.
So one thing I want to throw out just as we wrap up this section is, you know, CLTA has done a great job. And if you're in California, so many resources on figuring out how to navigate this, because as you've heard, there's so much to think about. And as we see laws enacted in other states and potentially at the federal level, know that there's a work group led by Liz and Samantha Budson, and Steve is such an active part of. That's where you're going to pull together resources for you so that you're not facing this alone, right? There's a lot to think about, and we're certainly going to be with you every step of the way. I do want to take a few minutes and talk about redaction, because this has become a hot topic on the federal and the state level. I think it's really important when you talk about any policy to understand the landscape around it. We talked about kind of everybody wanting to get their privacy rights back, and that's why data privacy is so important right now. Redaction, or as we like to call it, record shielding, has a really sad story to it right now. There's a judge in New Jersey whose son was horrifically and tragically shot in their home because somebody gained the personal address information of a judge and went to her home to cause harm. And so this has brought really this issue into national focus. The Today Show has run a few pieces on this, and I would encourage everybody in the industry to go look at those pieces. It is a heart-wrenching story, but what it really tells me is that we as an industry have an obligation to come up with a thoughtful approach about how to ensure that people's personal information is protected in things like the land records, so that it can't be used to do harm to at-risk groups. But at the same time, how do we approach this in a way that still allows for people to easily, you know, transfer real estate, buy, sell, or refinance? And so we've got a group together, which again, Steve and Liz are super active in and showing a lot of leadership on how to approach this. And Steve, I'd just like you to kick us off and talk a little bit about how do we as an industry need to look at this whole issue moving forward?
Well, I think one, and you mentioned, you know, Judge Sala and that terrible, you know, it was, you know, Daniel's law that passed in New Jersey. We cannot ignore the current climate and the pressure for shielding these records. As some states have addressed this over time, but it is a different climate that we have today. And you know, when you look at the news and you think about anger and things like that, just generally in our population. And then you look at something like what happened in New Jersey. And I think one of the big concerns and we're working on this at ALTA, Liz and Elizabeth, and trying to put together some tenets to think about. But there's unintended consequences that can happen from this. And Liz shared with me a really good article late last night regarding what's going down in New Jersey. And the fact is, everybody understands the passion and the need to be able to protect these types of records and protect our judges and possibly, key people in law enforcement, et cetera. And nobody's arguing that. But what has to be thought through and where we need to be really good stewards of our industry is how we message that. And the fact that, this all happened in New Jersey, but the county clerks, the county recorders themselves don't have good guidance and understanding of the best way to manage this process. So when we can step in, when we think this may be coming to a state near us or whatever, those are the things that we need to think about. And there was one piece from this article last night, and bear with me for a minute, because it came from one of the county clerks in the state of New Jersey, and they had a possible solution to compiling a whole list of judges and law enforcement officials. Have each impacted individual make the request, much like the New Jersey Address confidentiality program allows domestic violence victims to use a post office as a substitute. We need to be as thoughtful and engaged when we see these potential laws coming into our states. So we're not having the county clerks having to come up with some novel, creative way. This actually makes some sense. But this is the unintended consequences of a very topical, meaningful thing that we need to address. But it has to be thought through if at all possible, and we need to be as influential as we can within our jurisdictions.
Yeah, ALTA just in the last few days has reached out to the Uniform Law Commission and asked that they take a look at maybe drafting some model legislation around this. I think that would be good. Hopefully they'll make the decision in January to move forward with that. One thing we can say with certainty is that there has not been a uniform approach to laws in the states dealing with this, and this is a place where we as an industry can really show leadership. One of the things that our letter to the ULC outlined was that while there hasn't been a uniform approach, there's a couple of states that have laws that we like, Arizona and Minnesota. Liz, can you speak a little bit to why the solutions in these states work well?
Yeah, when you look at both states and the summaries of the laws are on the slide, and sort of the summaries look different. I mean, they're very different concepts, but what overlaps both concepts is that there's a means for the title industry and in other industries or industry partners that need legitimate access to the records to gain access to those records. And so that's critically important, in terms of ensuring that information that's essential to our business, we continue to have access to it. But that means of access is balanced against the need to protect the safety of the protected parties. And right. So in Arizona, it's a redaction process that happens after the record is recorded. So it's a post-transaction event, but there's a process, by application where certain industries are able to gain access to the unredacted records for those purposes. In Minnesota, the process is sort of the process of redacting or shielding land record information is actually sort of starts even before somebody who's in their Safe at Home program starts to look at potentially buying a home. I mean, the whole process is sort of cloaked in secrecy to protect that individual. But when the deed and other documents are made of record, a Minnesota Secretary of State identifier is associated with those records so that access can be gained by tracking through the Secretary of State that number and getting the approvals through that preordained process. So two very different looking processes, but ones that don't impact, issues like constructive notice or access to records that can be incredibly problematic for our industry.
So once again, Alta is trying to pull together information for you to use at the state level. We do have a new document out. It's FAQs. It talks about the Minnesota, Arizona approaches, and then it has this sort of list of best practices here that are things that should be consideration in your state legislation. So this is part of that thoughtful approach of how do we do this. You know, really the number one thing to think about is that permissioned access that Liz was talking about in Minnesota and Arizona, where the industry still has access to information it needs for real estate transfer, but the general public does not. Just one final slide quickly so people are aware. Federal legislation has been introduced on redaction by the senators from the state of New Jersey. Alta is meeting with Senate staff, talking about a few little tweaks we want in the legislation, the big one being that permission to access piece. The legislation is really positive in that it might provide some funding for states for implementation, which would lead to more uniformity and help the county recorders and clerks that Steve was talking about. So lots more to come on this topic. We are all here and available. I know all of us are happy to take questions if you reach out, but we appreciate having the time to chat with you all about this important topic today.
All right, there, pop back in here. Thank you all. Great information on data privacy and redaction. And it's going to be interesting to see how regulators, legislators continue to look at this holistically and kind of connect all the different pieces of this puzzle together. We are at the top of the hour. Maybe if you want to hang out with us for a few minutes, we'll try and get to a few of your questions. Otherwise, everyone's contact information is there on the presentation. Feel free to reach out to anyone. One question that we did have come in from Todd, and it's on the redaction piece, and he asked, how important is it to have consensus and support from state land title associations when mitigating redaction legislation? Anyone want to tackle that one? I'm guessing it's probably going to be very important to be working, at the state level with leaders in a particular market.
Yeah, I think this is such an important issue for our industry because we're sort of primary on its importance. So there are others who care about this issue, those who are maybe part of at-risk groups or representing those groups, obviously county recorders and clerks and lenders. But for us, we live and breathe the land records and constructive notice. So it is of vital importance to us. So it's an area that I really feel we have to lead on and lead in a really sensitive way. And I know Liz and Steve, you're both involved with state LTAs on efforts. So I'll let you jump in as well.
Yeah, Elizabeth, echo everything you said. I mean, we do have to take the lead on this. And so it's important that we lead with consensus, with a unified voice, and with a message that balances, appreciation for the safety risks and sort of the heightened importance of this issue for those who are protected parties, and at the same time clarify, what our need to access the records is, and how, essentially our ability to do that is ultimately helpful to those same groups, in the transfer or financing of real estate. So it is important to as one group, show consensus and strength in a unified voice.
I would just echo both of you. It is extremely important, and this is what we do, is manage, access to public records, and we need to preserve all the records to be appropriate so people can sell their homes and do refis and things like that. And it's a very, very strong message we need to be engaged with.
Thank you. How about when you guys are talking about disclosures, is that information that a title or settlement agent would then be sending out to consumers, say a transaction they get an order that's open and they start collecting data, then is that a disclosure they would then send out to the consumer, or is it also information that you need to disclose on your website?
I'll take a quick stab at that. It's both. There's disclosures that need to be on your website. When we mentioned, Liz and I both talked a little about digital advertising and how a website might be capturing certain levels of data. You go to most websites today, you'll see a little privacy pop-up. And it might say something like analytics are being done, or there's some things that we're tracking. Are you okay? That kind of stuff. So that's that's one, disclosure. There's other disclosures that are legally required to be on your website. And then there's disclosures that need to be provided on a transaction basis, similar to the Gramm-Leach-Bliley notice, when you're first engaging with a consumer. So it's kind of all of the above. Liz, did I miss something there?
You did not. That was perfect. Nothing to add.
Cool. Thanks, Steve. You guys had some great information for companies on how to get started. Any other suggestions for sources? What should a small operation with just a few people do to start this process? Is it talking with their underwriters as far as health preventers on this space? They can always go to ALTA's marketplace and search for vendors that offer data privacy and cybersecurity. And any other suggestions for people to help getting their plan together?
Be very active with ALTA and your state land title association.
Mm-hmm. Yeah, all of the above have been great resources, and there's also, there's some good law firm, materials out there that are accessible to anyone. Some of the regulators have put out, papers, helpful information on what sort of shapes their view of compliance with the law, how they interpret compliance with the law. So that can be a helpful and free resource as well.
I think too, it's a good first step is just starting the mapping process. Even if you don't get all the way done with it, what information do you collect? When do you collect it? How long do you keep it? Where is it stored? Who do you share it with? Having all that information sort of gathered on the front end is going to help you get the most out of conversations, whether it be with, underwriters, counsel, or others.
Yeah, I definitely think understanding how you accept, use, store, share data goes a long way to answering a lot of your questions. Well, we're almost 10 minutes past the hour, so thank you to nearly 100 people out there that are still hanging out with us. So hopefully you enjoyed the program and the content. If you missed parts of today's webinar, or if you think others in your office would benefit from listening, as I mentioned before, recording of the presentation will be emailed out to you. Again, you can always find the recordings on Alta's website at alta.org/webinars. And that will bring us to the conclusion of today's presentation. To wrap up, I do need to thank Old Republic once again for sponsoring our compliance webinars. And just peeking ahead a little bit, in January, we will be offering a webinar on how to increase engagement in the remote working environment. And we will also be providing a presentation forecasting the 2021 housing market. And also just need to provide a quick mention of the ALTA registry. Just as a reminder, being an ALTA member or a policy forms license holder does not mean your company is automatically in the registry. So go to alta.org/registry for information on how to get included in that. Again, thank you to Liz and Steve, as well as Elizabeth, for joining us today and sharing information on data privacy and redaction. Take care, everyone.
Thanks.
Thank you.
Thank you.